you very much, Mr. Chairman, and thank you for being here today, Madam Secretary. I appreciate when you come to visit our committee each year. Just for a point of clarification, there will be no votes today. I know you were just suggesting that we are discussing the future votes on these bills, but there will be no votes today. This is merely a public hearing. We have a very long schedule today. We have quite a few speakers lined up. I think everyone from experience will know that I could keep you on this witness stand for quite some time, asking a lot of questions and details about these items. But I'm going to try and move it along as quickly as I can today, just because we have so many people. I appreciate your opening remarks suggesting that this is not a partisan issue, and that there are a great many people when they hear the term early voting or increasing access. It's wildly popular. And of course it is. No one wants to restrict anyone's ability from voting. And that should be abundantly clear as a point for anyone that's discussing this issue, regardless of their political party. Sadly, unfortunately, it always appears that anyone that opposes these measures or the language in any of these bills is somehow characterized as someone who is against expanding access to voting. And that couldn't be farther from the truth. I think you know as well as I do that the issue is that sometimes the devil's in the details. And for me personally, I was looking forward to supporting some sort of early voting measure as long as it was limited and maintained the integrity of elections. But I ultimately voted no on this resolution, which we have before us, which is House Resolution 59, I think it is, which is the early voting one. And that is because it makes a constitutional change simply to say that there will be early voting allowed. So I guess my first question for you, Madam Secretary, really is there a reason why we want to modify the Constitution to simply allow for early voting without specifying a time limit? I made the point during the Senate debate that when you say early voting, that could be 1 day, 3 days, 7 days, 30 days. And in fact, the way the bill is written, it could mean early voting could begin the day after the previous election ends. And that's a concern of mine. I would much rather see something that was a little tighter, especially since it's in our Constitution. So looking for your reaction to that.
Sure. Thank you, Senator Sampson. Nice to be here. And you and I have discussed this at length many times. But I would simply say that the very specific rules about exactly how we administer election are in statute now and should be devised by the legislature, which is the body that makes all laws. State constitutions are really broad statements of policy in many cases and shouldn't be the place where we put the specific rules in, because just like we're finding right now, it's very difficult to change them. So let's say we put in the state constitution a specific number of days of early voting. Well, what if somehow that became unworkable for whatever reason? There could be a lot of reasons that suddenly 3 days wasn't the right number of days, or who knows? And so that's what we're looking for here, is for the legislature to set those rules as they set every other rule. As it is now, unless there was action, nothing would change. In fact, there wouldn't be days of early voting until, first of all the voters vote for it on the ballot. And second of all, the statutes that are in place would remain there until someone changed them. So it's potentially possible with this particular version of the amendment that we wouldn't have any days of early voting. It makes it permissive for the legislature to decide, as they should. That is the proper place to make these decisions.
Yeah, respectfully, I would say that the Constitution already does specify that elections happen on 1 day. So that is specified in the Constitution. And I would also say that it also requires that voting, unless very, very specific other circumstances occur, it must be done in person. I think those are two very important regulations that are contained within the Constitution itself. But I guess, so I get your point, which is that you feel like it should be open to the entire legislature by statute. I disagree. I think that the Constitution is there as our saving grace, the thing that when we have one party rule for 40 years or we have major disagreement across the state on things, the Constitution saves us because we can always go back and say, well, at least we have this concrete foundation to stand on. So assuming this did pass, what would you advocate for the General Assembly for a time limit? Would it be 3 days? Would it be 7 days? Would you accommodate weekend days? Would we want to skip weekends? Just what would your vision be, Madam Secretary?
I think we can't even get to that conversation until we have this language out of the state constitution. I've made several suggestions in the past, and we have lots of states to look at as examples. Texas, for example, has 30 days of early voting. Some state, Iowa has 29 days. It's all over the place in the country, but there's lots of experience to look at as to how they do it. Florida, for example, they have 10 days of early voting, but they don't open all their polling places. They open like town hall and sometimes the libraries, places that are already open. So you have to take into consideration things like cost and whether we're still going to be doing elections in every town. We are the only state now that does elections by town rather than by county. And technology may come to bear on some of this. So I think all of that is exactly what needs to be debated by this legislature. And we have to get to that point where we'll be at least able to have those conversations. And I look forward to it.
All right, thank you very much for that. I mean, I don't disagree. And you brought up quite a few additional areas of concern, costs, not the least of which, if you have 3 days of early voting, now you have to have, some mechanism to be able to collect those votes. If it's 30 days, it's going to be even more substantial. And it's just we do have towns handling our elections currently. So it is a factor that we've definitely got to delve into. But I'd say even more important than the cost is how are we collecting these votes? Because the first thing that comes to mind for me, Madam Secretary, is when we're collecting votes. Right now, we don't count the votes until 8 p.m. occurs and the election is officially over, and then you have the tabulators are run their tapes and everybody gets the results. How do you envision multi-day voting occurring? Would we be getting the results on a daily basis, or would the tabulator machines just be left open during this period of time?
Again, by passing this amendment, nothing changes from the way we're doing things currently. It just allows for change should the legislature decide that. So again, those are the debates that are going to have to occur if you want to change anything at all. Maybe not. I don't know. But that's something we can't even get to the question until we have the ability to have the flexibility to even make a change like that.
Respectfully, Madam Secretary, all I would say is we're being asked to make a very, very significant change. We're changing the Constitution of the state of Connecticut that has existed in the same way on this subject since its beginning. And the thing is, we have no details. And, the thing about the Constitution is that it requires a significant effort to make a change. We've got to have a 3/4 majority, or we've got to have 2 consecutive legislatures agree, and then we have to have the people vote by a ballot measure. What's happening with this constitutional amendment is essentially we're transferring all of that power, authority, and sacred nature of our constitutional language to the legislature to change anytime they want based on a simple majority. So respectfully, I'm just like, I don't want to say, well, let's get rid of the concrete, hard and fast thing for a bunch of unknowns. And I feel like it's important. And I think that, as you mentioned in your opening remarks, you said, 79% of people are in favor of early voting. Well, if I said, are you in favor of 3 days of early voting? I'm going to get a different result than are you in favor of 364 days worth of early voting? And that's just a fact. And it's worth noting. And when we start to talk about the no excuse ballot initiative, I want to bring up the ballot question because that goes straight to the heart of that. The tabulator issue is important because you either have 2 choices. You're either going to shut down your machines every day, in which case someone is going to know the results of the election on a day-to-day basis. And that cannot be good. because that information is going to make it into the public and it will impact the results. Or you're going to have tabulating machines being left open for 24 hours a day. And as we witnessed in the presidential election, there's great concern among some people. I don't know that you have this concern, but there are definitely people out there that are concerned about the integrity of our election process when it comes to making sure that the elections themselves are monitored, that the machines are monitored properly, and that there's no funny business going on. We also have a process for in absentee ballots. When someone casts a vote and then something changes, they can actually pull their ballot back up to a certain point. I just wonder if that is something that you envision existing in the early voting process. Through you, Mr. Chairman, to the Madam Secretary.
Yes. All I can say is nothing changes under the amendments until the legislature changes it. So our current process, which has all kinds of checks and balances, as you know, to protect the integrity of our elections, we have not really had any widespread problems with any of this. And it's very unfortunate that people feel that there's some problem with the integrity of our elections in Connecticut. Nothing could be further from the truth. And none of us have envisioned any changes in the process thus far. We changed very little about our process, even during this very difficult situation where people were not able to come to the polling places due to the threat of COVID. It's a very reasonable threat. It was a very reasonable reaction by the voters that they needed to have an ability to get an absentee ballot, and they couldn't because of the restrictions that are very limited in our state constitution. We have arguably the most restrictions on voting for voters in the country. Almost every other state allows this. And by the way, we've had absentee balloting in Connecticut for over 100 years. And we're just going to have more of them now as people need that availability when it comes to a situation like we had in 2020. So, I can only say again that those discussions will have to be held when we get the availability of being able to even we can't even get to the discussion until we have the possibility of having this flexibility. So there's really no point in arguing how you're going to manage early voting or whatever it is without having the possibility of having it. Like I say, there are plenty of states that are doing it now, 40, I believe. And so obviously there's ways around whatever problem you can present with if it worked this way or that way, if there were 3 days or 40 days or whatever, because everybody's already doing it. And so it's not difficult to imagine how we would be able to make it work even within our current system. We just have to have a way to make sure that the clerks and the registrars have the tools they need to be able to continue to make the integrity of the election work. And that's with all the many checks and balances we have in place now, including monitoring the tabulators. We open the tabulators publicly. We send the computer chip that's in the tabulator to the Yukon Voting Center to make sure the programming is correct. I mean, we have multiple steps along the way that are very well regulated. And I am very confident of Connecticut's elections, quite frankly. And it's largely because we have instituted so many processes. And to be honest, it makes it somewhat cumbersome, but it's probably worth it to ensure that everything is going the way it should. And so I don't think anything changes under these amendments. We will still probably do elections the way we're doing them today because it will still be in statute. And by the way, I still think that all the voters of the states ought to be the ones to decide if they want this flexibility or not. That's all we're doing here, is allowing them to decide.
Madam Secretary, thank you very much for that answer. You can tell you were in the legislature at one time, since your filibustering skills are quite good. And I mean that respectfully. You just covered a lot of ground there that I was not asking about. And I'm trying to stay on track. I mean, I was talking about early voting, and you've segued into no excuse, which I'm happy to talk about also. It seems like on the early voting issue, I'm not going to get a lot of concrete information other than you believe that we should have early voting and the legislature should make up the rules. I just, end that discussion by saying that I think that, the Constitution does have very specific requirements. The fact that it's in person on one-day voting. And before we change that, I think that the public deserves to know what we're changing it into. And I think that it's just unfair to, approach it with, do you like the idea of early voting? Yes or no? Because that's not the end game. The end game is it's going to be some very, very complex set of circumstances by which early voting will be implemented. And the public will not have that information when they get to vote. And that's unfair. They should know whether they're voting on 3 days of early voting or 30 days of early voting, or whether it's in person, or whether or not the tabulator machines will be left open, whether or not there will be drop boxes. They should know what the parameters are. I respect the fact that you believe that our elections are perfect. I disagree. I'm sorry, respectfully, I do. There are a great many people that are concerned about the way our elections have gone over the last decade. It seems like almost every day after Election Day, there is a report of something. We've had mass swearing in ceremonies happening after the fact. We've had, found bags of ballots, lots of things. I had folks send me information for today's hearing showing ballot boxes stuffed with so many ballots that they're hanging out of the box. Now, I mean, that cannot maintain the chain of custody or the integrity of the vote in a way that matters. During the debate in the Senate over the summer, I brought hundreds of examples of people that received mailed absentee ballot applications that they did not ask for, that were duplicates, that were for people that moved away, people that passed on. It was extremely problematic. You can't say that it was a perfect election in that respect. I'm not suggesting that our elections are fraught with fraud or that anyone's results were compromised, but we also don't know exactly what happened with all those mass mailing of absentee ballot applications. It is the kind of thing where I think even you would admit that in-person voting is always going to have a higher degree of accuracy than absentee voting for a combination of reasons. Number one, you can verify the person who's in front of you when they're voting in person. Even Senator Looney has said on the floor of the Senate that we actually never really know who's filling out an absentee ballot. That's a quote from the Senate Majority Leader. And the other thing about that is that a lot of people end up disenfranchised because their absentee ballots are sent back and they are not counted because they're filled out in error or something like that. Which leads me to my next question, which is if we're going to talk about expanding the Constitution to include no excuse absentee voting, I guess the very first question I would have is, why are we changing the question? In 2014, the legislature passed a similar amendment and it went on the ballot. And the question at the time read, shall the Constitution of the state be amended to remove restrictions concerning absentee ballots and to permit a person to vote without appearing at a polling place on the day of the election? And that failed. People of the state of Connecticut voted it down. They said no. And I think it's because they said no, but we really want people to appear at the polls. And yet this time around, we're going to try and do the same thing, but we're going to change the question. And this is very curious to me. Why are we changing the question? The question now reads, shall the Constitution of the state be amended to permit the General Assembly to allow any voter for any reason to vote by absentee ballot? I mean, these are two very different questions. The first one's much more specific. It raises a concern. So, Madam Secretary, I don't know if you had any direct involvement in choosing the wording for the question, but do you have any concerns about it? Do you think that we should go back to the first question?
No, I actually believe that the first question was very confusingly worded for the public. But I also think times have changed. I think the 2020 election revealed that people could vote by absentee ballot safely and securely. And I think they enjoyed it. And they saw that the rest of the country was already doing it. And I think it made a difference in the way people thought about it. They saw it in action, so to speak. So, we may be in a different place now. I guess we'll find out. But the two different questions are in response, I think, and my office is not in charge of the wording of the question, by the way. That would be done by LCO ultimately. But it would be in whatever bill passes, whatever, the wording is. But why it was widely believed that the question, people didn't understand the question at all. And it wasn't such an issue as it is today.
Thank you for that. I disagree completely. I think they understood exactly what it meant, which is that we would be allowing people to vote without appearing in person at a polling place. And I believe that raises concerns for a great number of people. And I think taking it out of the question is dishonest. And I will continue to make that argument along the way, even though I'm not even against the idea of expanding absentee voting. But the thing is, I am in favor of maintaining the integrity of elections, and I am in the favor of being completely honest with the voters about what's happening. During the recent election, you expanded absentee voting exponentially. It went from 4 or 5%, I think, as you mentioned, is typical, to like 35%. 600,000 people, something like that, voted by absentee. And true or false, does the state of Connecticut even have any sort of verification system for signatures on absentee ballots?
No, we don't use a signature verification process. The only time that's used is in states where they actually mail the ballots to people. And there are quite a few where they simply mail the ballot to someone. Then they do have a signature verification process. We don't have that here. We have other ways to check to make sure that that person is on the list.
But what is the way that we verify that the actual person that ballot belongs to is the person that completed that ballot? Through you, Mr. Chairman.
Well, we do have, people sign it. There's a signature under penalty of perjury. I mean, you would have to be forging someone else's signature, and that's a very serious offense.
My understanding is that with no signature verification, no one has to forge anything. I've been told by the registrars that they were instructed if there was a mark made where the signature belongs, that they count it. It doesn't even have to be a signature. It doesn't have to match anything. I mean, I think, Madam Secretary, the whole issue with absentee ballots is that historically they've been extremely limited because there is a lot less ability to verify their authenticity than an in-person vote. And that's by design. And that's why the people that drafted our Constitution put in very specific excuses. When you get rid of those excuses, you must absolutely, as a requirement, as an obligation to the other voters in the state whose votes must count, do something to verify that those absentee votes are legitimate. And I don't believe that's being done.
Well, if I could just respond by telling you what our process is. First of all, we have a whole application process. You need to apply for an absentee ballot. You need to sign that application with your name and verify. Then it is sent to the town clerks. They verify that that person is on the list at that address. They then mail the ballot to the person, and the person has to receive it at that address. So if someone were going to send in a ballot for someone else, which is what you're suggesting, they would have to forge that person's name on the application. They would have to trust the fact that that person didn't, by the way, sign up for that application themselves somewhere else, because then they would be caught. They would then have to receive the ballot itself back at their address where it was sent. And then they would have to sign a second time, forge that person's name, send the ballot back, and then that ballot would be recorded, right, as having that person has now voted by absentee ballot. And if that happened and that person actually showed up at the polls, then the person, whoever signed that, would be committing a felony. And I think there would be few people be willing to take all that risk to sign one false absentee ballot. So there are a lot of ways that we check on these things. Signature verification, frankly, is not a very good way of verifying authenticity. There are, states that use it, and the states I've talked to are not particularly happy with it. People's signatures change over time. It's just like all these methods of verification. And I think, frankly, over time, technology is going to take over all of this because there are more and more ways you can check people's identity in different ways than signatures or whatever, thumbprints or whatever other ways. You just have to remember that every time you put something in place that's going to disenfranchise someone, like making sure their signature is checked, that adds a burden not only to the people administering the election, but you're also placing a barrier. Every time you put in place another process by which somebody can be rejected, and that's what you're talking about, then potentially someone is not going to be able to vote.
Yes.
So we're very, very careful before we disallow any voter, whether it's absentee or in person.
So, Madam Secretary, 2 points based on your remarks. First off, it absolutely did happen. I saw several examples in my own election where voters contacted me and said that they were at the polls, they were attempting to vote, and they were not allowed to vote because their vote had already been cast. And after
did you report that to this Election Enforcement Commission?
I don't know that the proper mechanism. My RTC chairman and the registrar of voters are both very aware of what happened. And we basically had to go back and go through a process of finding the absentee ballot that had replaced this person who tried to vote in person at the polls. And, you know, that's the thing you left out of your commentary, which is that if someone votes by absentee because they receive a ballot application in the mail, complete it and get a ballot and complete it, no one will ever know who that person is. And then when the actual person shows up at the polls, it will indicate that they've already voted. And I'm telling you, I can confirm that happened in several cases that I am personally aware of. And it's neither here nor there. The larger point that you made, which is you're concerned about disenfranchised voters, but so am I. And Madam Chairman, the issue is that when you use absentee ballots, there is a percentage of voters that are disenfranchised when you use absentee ballots. That doesn't happen when people vote in person. When people vote in person, their votes count. But you know as well as I do that even in this election where we did almost no verification, no signature verification, the registrars were more or less informed to count every ballot that they could, there was still 6,000 some odd people whose votes were not counted because they didn't complete the envelope or they put 2 ballots in an envelope or something like that. That doesn't happen in in-person voting. And that's a concern of mine. I don't want to see 6,000 people or more. And as the number of absentee ballots goes up, that number will increase. There's no doubt about that. What are we doing to make sure that if we expand our Constitution to say there's no excuse absentee voting and the number of absentee votes goes up dramatically, what are we going to do to prevent those people from being disenfranchised?
Well, again, should these measures pass and should it pass on the ballot, then the legislature could potentially put more protections in place if they thought it was necessary. They could do that now, for that matter. So I don't know if the number of absentee ballots makes the difference between, you know, the way we're doing it now and the way you might potentially do it just because there's more of them. You know, and we've been doing this for, 100 years, as I said. And by the way, the rest of the country is already doing this. Many, many states have much more expanded absentee balloting than we do. So I don't know how we can remain such outliers in this when there are plenty of places you can look to see if you want more checks and balances than we have already.
I believe you and I are in agreement, Madam Secretary. The difference is you want to change the Constitution right away, and I want to put those checks and balances in place. I have proposed as a ranking member of this committee year after year, audits of Election Day registration, audits of absentee ballots, signature verification, photo identification, things that would restore the integrity of our elections. And we're not doing any of those things. I hope that when we have the public hearing for those audits, that you come and testify in favor of my bills. I mean, I'd like to see that. Are these people told, by the way, if I send in my absentee ballot And like, I know a lot of elderly people, sometimes they're being frugal and they'll take the husband and wife, will put the two ballots in one envelope and they send it back. And that's a very common way that those ballots are not counted because they're not filled out properly because they're only in one envelope. Are those people ever informed that their votes did not count?
We did have special rules this year for that, but I would point out that we had a lower return rate of what do you call it, defective ballots than ever before. It was half the rate it usually is. And I think it probably is because of some of the changes we made temporarily in the bill that the legislature passed in special session that helped us deal with these situations. But I guess it's not surprising considering, the incredible increase in the number of people that were using absentee ballots, which is why we had to do so much public information about how they were supposed to work. And one of the reasons we have that, and we have made proposals, by the way, and I am supporting some proposals this year to increase the number of, for example, to increase the audit process. I would like to go to a risk limiting audit type of situation. I think it's very needed and probably more effective, but I'm sure my friend Luther Weeks can tell me more about that. But I do think we ought to do everything we can to do post-election audits that also increase people's faith in the integrity of things. So there's things, there are more things that we can do about that. But go ahead.
I hope we can find some agreement. Again, I started this conversation with you by saying that I'm not opposed to either one of these constitutional amendments in theory. It is in practice, and it is that I believe when you expand voting, you have an obligation to maintain integrity. Not one or the other. Both are absolutely required simultaneously. And I'm glad you're in agreement. I hope we can actually fulfill that promise by passing the necessary requirements to improve integrity along the way. I know I've gone a long time with you and people are getting impatient, but I have to follow up on just the last two bills with you, which is the COVID-19 extension bills. And I got to tell you, Madam Secretary, this whole thing has been quite a bone of contention with me since the beginning, because I think a lot of people in the state were misled about this legislation when it passed during the summer. I think it's ironic that we actually have the conversation right now and this proposed bill changing our Constitution to allow for no excuse absentee voting, when in effect we just had an election with no excuse absentee voting, which kind of leads one to believe, was that election constitutional? Which is the question that I have. I want to understand exactly what the proposal was initially to change our law to add COVID-19 as an acceptable excuse under our current constitutional law for no excuse voting. How does that work? This is what I'm confused about. Maybe you can clarify for me. The Constitution already says illness. Wouldn't COVID-19 have already been covered through you, Mr. Chairman?
Yeah, I think the question was whether or not people could get an absentee ballot under that provision if they were not actually ill, if fear of illness or potential, in a pandemic situation, you had a very, very special situation where people, if they had gone to the polling place, could have contracted the virus, particularly people with underlying health conditions and the elderly. So that was why we put that qualification, I guess I'd call it, in the statute.
I understand that, Madam Secretary. I guess the question I have is, why didn't we say fear of COVID? I suspect because if we had said fear of COVID as an acceptable reason, it would not have complied with our Constitution.
Oh, sorry, someone's talking to me in the background. Yeah, actually, well, it's legislative language. And so it was devised by the legislature, not by me. But I think that was the rationale was under an emergency situation, given the fear of COVID, a rational fear, and the concern for voters not being able to vote. And they just put that language in that expressed the opinion. In a sense, I guess the legislative intent must have been to have it come under the sickness provision, unable to get to the polls due to sickness.
Yeah, well, thank you for that answer, Madam Secretary. I guess, so I remain bamboozled, and I think so does a lot of the public. I would have been glad to support a constitutional amendment to include fear of the COVID pandemic, but we didn't do that. What we did was we passed a law that said not that COVID-19 was an illness under the constitutional parameter that illness is an acceptable excuse. We just made a whole brand new excuse and we named it COVID-19 without specifying whether it was actually being sick with COVID-19 or the fear of COVID-19. And then you took it upon yourself as our Secretary of State to send out absentee ballot applications to every person on the voter rolls in the state, which I really wanted to get into that conversation about our voter rolls, but I'm going to save it because I know that we've already gone long enough. But when you said on this form, all voters are able to check this box, I think you were taking it upon yourself to suggest that it was fear of COVID. I don't think that the legislature passed anything that said that.
Oh, no, I disagree. The reason we sent the applications out was to inform voters of their rights under that emergency order and under the executive order and eventually under the legislative decree. I think it was my obligation to let people know about the change. And it did, there was a lot of confusion at the time. And the way, when I sent those applications out, it was specifically for voter information. And they needed that. People were totally confused and scared about whether they would have their opportunity to vote. And so that's under that. And by the way, applications for absentee ballots are widely available to anyone who goes on my website or any town website. There's nothing special about getting an application for absentee ballots. As a matter of fact, routinely candidates mail applications to their constituencies when they're running for office. It's done all the time. And so this is, everyone's making much of this mailing of the applications. It was absolutely necessary to let the voters know what their rights were.
Well, Madam Secretary, I agree with you that it's no big deal to go and apply for an application online. They're readily available. And in my opinion, that's what you should have done, was inform the public, use the federal money to do a PSA or something to tell people that they have the ability to obtain one. The mass mailing basically created problems because the voter rolls are so inaccurate. I know that we're going to have some folks from Fight Voter Fraud up on our agenda today. I'm sure they're going to be able to tell us a lot more about just how incorrect our voter rolls are. Those examples I made during the special session of all those people that received those ballots or those ballot applications are examples. I don't want to get off track on this, Madam Secretary, and I don't want to litigate a constitutional matter, but I do want to suggest to you that when I was in the special session voting on COVID-19 being an acceptable reason, I was not thinking that that was going to enable every person to check a box that you indicated in bold print that they can vote because of fear of COVID. That's not what I was led to believe. I was led to believe that the illness of COVID-19 falls under our constitutional parameters. The fear of COVID is not a constitutional provision. I would have gladly voted for that because I agree with you that we should have made every accommodation to voters, but we didn't. We went around the Constitution. And in fact, this mass mailing of the ballot applications with the bold print invited people to go around the Constitution because illness is a acceptable reason. But COVID-19 as an illness counts, but fear of COVID is not something that would fit into our current constitutional rules. And I think that it's a shame that it all worked out the way it did. I don't think it was done honestly with the voters. Respectfully, I just got to say that even as ranking member of this committee, someone who you would think is as informed about these election laws as anyone, I was completely baffled when that happened because that's not the way I envisioned the law that was passed.
Well, I believe it was an absolutely legal interpretation of exactly what was passed. And moreover, I feel it was one of the most important things we did because people needed to know that that process was available to them so they wouldn't have to stand in line or worse, not vote at all. And that was the choice people were facing. So to go back and try to put yourself in the place where we were last summer is difficult at this point because things have worked. We're in a different place than we were even then. But it was terribly important that we let people know what was going on. And that was... You and I are in agreement a lot today.
We are in agreement on almost everything. I find that very interesting, and yet we have different ways to approach it. I believe everyone should have been able to vote based on the fear of COVID, but we never passed a law to allow that. And it is unconstitutional without changing the Constitution. And that's just the way it is. And maybe someday we'll get to litigate that.
Well, actually, if you'll indulge me for just a moment, I believe my election attorney manager is on the line. Ted, are you there? Ted Bromley. This was litigated, quite frankly. And I'm forgetting now how many, because we were sued a number of times over these kinds of issues at the time, as people tried to say, oh, no, it's constitutional. It isn't constitutional. And I believe this issue was litigated. Ted?
Oh, there was a case, but the issue was never litigated.
There was a case that was...
It was dismissed because of the special session vote.
Yes, that's right.
Yeah. Well, I understand that, but that didn't change anything. And again, we're taking up time from this committee that on a side issue, and I apologize to the committee for bringing it up. Although I think it's important because the bills that we have before us that extend those provisions are also misleading in that they are implying that someone can vote by absentee for fear of COVID, and that would not be constitutionally correct. It's just that simple. The Constitution has parameters. You're in the military, you're going to be out of town, or illness. If it doesn't fall under those parameters, then it's not constitutional. And fear of an illness is not the same thing as your personal sickness, which is what our Constitution states. And when we passed the special session law and said COVID-19 is a special example, any person who understands our Constitution merely thought we were being duplicative in specifying a particular illness in COVID-19, not expanding that to mean something beyond the illness itself.
I just respond that I don't think we can litigate that right here, but we were on firm legal ground with all the things that we told people, and that's all I can say. And we can have a conversation about voter lists at another time, but I will just say that our voter lists are much more accurate than almost any in the country. We actually got recognition for that fact. Yes, of course, there's tremendous mobility. The list is not a static list. It changes all the time. It is kept up by every one of the 2 registrars in every one of the 169 towns, 1 Republican, 1 Democrat. They do their best to keep these lists up. And we have lots of tools, including we discussed about the ERIC system and so forth. So I think to say that the lists are inaccurate is probably not true. Of course, anecdotally, you hear all these stories about people getting absentee ballots for, or applications for dead people and people that are no longer there. Of course, that's true. That's always going to be true. People move a lot and they don't keep up their addresses as they should. But we still have as accurate as they need to be. And the registrars, I would defend the registrars in saying they do the best they can to keep these lists up. We do an annual canvas. We do many things to make sure that they're as accurate as possible. Could we do more? I don't know. I'm open to suggestion, but it's all done at the local level. So if you have questions about that, we need to look at the whole system.
All right. Thank you very much, Madam Secretary. We'll have to disagree on the accuracy of the voter rolls. I think that it's more than just anecdotal information. I had numerous, literally hundreds of people contact me from my own district. I cited dozens of these examples during the floor debate. I'll be happy to do that again when this comes around again. I would much rather that we had a better solution, though, which is you and I put the things that we agree on about voter integrity, audits, signature verification, and so on into law before we go changing our Constitution. And I will leave it at that. Thank you very much, Madam Secretary, and thank you, Mr. Chairman, for your indulgence this morning.
Thank you, Senator Sampson. Appreciate your commentary and questions, as always.